Welcome, and thank you for joining today's webinar, Navigating the SEC Rules for Enhanced Cybersecurity in IT and OT Environments, featuring experts from Dragos and Pillsbury. My name is Jennifer Halsey, and I'll be your moderator to kick things off and facilitate the question and answer session at the end of the webinar. Before we get started, this session is being recorded and will be sent out to all registrants after the webinar. Microphones have been muted and the chat is disabled, but we still want to interact with you. So please use the Q&A for any questions and we'll get to them at the end of the presentation. If there isn't time for all the questions, we will email you with an answer if we don't get to yours. So some background on today's topic. As of December 18th, 2023, public traded organizations must comply with the SEC's incident disclosure regulations, which were originally unveiled in July. Under the new rules, publicly traded companies will be required to report cyber incidents within 4 business days of determining that the incident is material, meaning it would potentially impact a shareholder's investment decisions. Our panel of speakers will help us unpack these requirements and how they'll impact your cybersecurity programs. We have experts here today from Dragos, a global industrial cybersecurity company that offers a technology platform, threat intelligence, incident response retainers, penetration testing, and more. Dragos has partnered with Pillsbury on this webinar, and Pillsbury is a full-service law firm with a particular focus on the energy and technology industries. Our panel today includes Betsy Guarini, General Counsel at Dragos, Mark Stacy, Director of Strategy at Dragos, Brian Finch, co-leader of Pillsbury's Cybersecurity Data Protection and Privacy Practice, and David Olowinstein, a partner at Pillsbury with an extensive background in SEC investigations. We are going to start with a view of the cybersecurity threat landscape with Mark Stacy of Dragos, giving us a quick overview of what we're facing when we're defending industrial environments. Mark, take it away.
Thank you, Jennifer. So I like that we're starting this webinar with the only non-lawyer kicking it off. And we're doing that because I think it's important to really identify the influencers and why we're seeing some of these changes in the industry. Focusing on the right part of the slide, especially when we're talking about OT environments, the impact goes past information and data loss. We start talking about public safety, environmental concerns, and ultimately impact to not just operations, but potentially staff, to include human health and safety. So it's worth it to look at the evolution. Why we're seeing the industry changes, why we're seeing the White House routinely talk about cybersecurity, specifically OT cybersecurity, as well as regulatory changes like we're talking about today. And generally, whenever we talk about cybersecurity, there's kind of an overarching doomsday message. We want to avoid that. We want to focus on actual evidence that we've seen in the field that we can rely on rather than hyperbole. So a quick couple examples of that maturing landscape. First, starting in 2015, we had crash override take place in Ukraine. There have been evidences before of seeing a digital signal manifested in the physical world, whether it's the Aurora attack at INL through Stuxnet, but crash override was the first time we really saw impact a critical infrastructure involving a population, where the distribution of electric power was not only dropped down or impacted, but return to service was impacted as well. This showed an opportunity to impact, again, a civilian's critical infrastructure and have potentially propagating effects. In 2017, Dragos worked with partners to develop what we call analysis on Trisis. This was malware that targeted the Triconic safety system. The only point of a safety instrumentation system, or SIS, is to provide safety and safe environments for the staff, safe shutdown and management of the operational system. By targeting this with malware, it demonstrated really a motivation to impact health and human safety. So we've seen opportunity, motivation demonstrate itself. And then in 2022, we saw really hints towards that final remaining component, and that is capability. Dragos worked with other federal partners to do analysis on what we call pipe dream. This is the first real scalable capability that allows not just triage, but has built-in functionality for destruction and disruption of operational technology environments. It lowers the cost of entry for an adversary to have an impact. So now we've seen opportunity, motivation, and finally a capability that allows the threat landscape to scale, where again, our adversaries don't have to be subject matter experts. They don't have to understand the physical profile of the environment to be able to have that impact. It is important to note that we haven't seen Pipe Dream necessarily in the wild. Right now, it is a capability that we haven't seen in active use, but that time will change. I've often said that the APT malware of today will be the commodity malware of tomorrow. During times of conflict, these sophisticated entities that have built these capabilities may be encouraged to use them. Anytime they do that and the industry sees it, we have people analyze it and report on it, that capability is now out in the wild and can be leveraged. We saw that with Eternal Blue and ransomware. And so right now, while Pipe Dream is not out there in the wild, eventually it may be. And so being on the leading edge of this, being proactive in this approach allows us to really prepare for what the implications could be. So Brian, I'll hand it over to you to get into subject matter expert today.
Great. Thanks, Mark. And first of all, really appreciate the opportunity to partner with Dragos on this. You guys are obviously the world leader on operational technology security, which is it's a great opportunity for us to complement what you bring to the table by talking about some of the legal issues associated with cybersecurity, particularly in light of what the Securities and Exchange Commission has done. And what they have done is really, it's a bit of a sea change. It's nothing new, but it's also deeply impactful. It is really it's an interesting turn. And it's impactful in that, now for the first time, companies, publicly traded companies and regulated companies are going to have to regularly and clearly disclose when there has been a cybersecurity incident. In the past, it's, the overused phrase, a patchwork. It's definitely been a patchwork of laws, depending on whether private information, personally identifiable information, protected health information, et cetera, your credit card, every credit card in my wallet has been stolen. I can't tell you how many times. I seem to have enough credit monitoring to last me all the rest of my days and then some. So we're all familiar with those types of disclosure requirements, but now we're talking about obligations on the part of publicly traded companies to not only talk about when they've had an incident in a very timely and sort of almost rushed fashion, but also talk about what they're doing beforehand in order to mitigate those risks. And this is live, as Mark and Jennifer and others have been talking about, and my partner David will go into greater depth on this. This is a live obligation at this point. It's been talked about for several years, but as of December 2023, if you're now a publicly traded company, you're in the position now that you need to disclose when you've had a material cyber incident. And David and I will talk a little bit more about that. But this is happening. We've seen Microsoft disclose, for instance, that they've suffered a cyber incident just in the past few weeks where some emails were penetrated by an adversary. Microsoft also said, well, we don't think this is material, but we're going to disclose it anyways. I think that, not to speak for Microsoft, but I think it's a fair guess, shall we say, that Microsoft wouldn't necessarily put out a public statement about that if it wasn't feeling pressure from the SEC. And what specifically has the SEC called for in this particular instance with this cybersecurity disclosure rule? So as discussed and as obvious, anytime there's a material cybersecurity incident, that has to be disclosed within 4 business days of the materiality determination. And what you have to disclose are the material aspects, including the nature, the scope, and the timing, and the impact or reasonably likely impact on the company, including for financial conditions and operations. This is dramatically new. And this is different if you're a government contractor and you've got to disclose within 72, 24, sometimes 8 hours that you've suffered a cyber incident. This is going out to the broad world. It's going to be mentioned on CNBC. It's going to be mentioned on Bloomberg and might show up in all the major newspapers. It's not going into some government memory hole. We're going to get a follow-up with an investigator. And potentially in a couple months, at your own discretion, you're going to disclose it. This is going to be out in public. There are possibilities of delays, and we'll talk about that a little bit more, of upwards of 4 months or 120 days, perhaps even beyond that. But the reality is that this is an obligation that you're basically going to have 96 hours from a determination that it has occurred and that it is material. And it's an ongoing obligation, meaning that you're going to have to continue to provide information to investors and to the public writ large about what exactly has occurred, and that there will be amendments to your first disclosure. And a really critical point here is that the SEC is operating from a somewhat unique perspective here, which everyone is going to want to keep in mind. This is not a national security incentivized, oriented type of disclosure rule. This isn't one about protecting public information or protected health information. If you want to ask me what drugs I'm on, and believe me, by my pill case, there's a lot of it. That information is out there. You can find it. You know, we can talk about my eczema and adult acne at another point, but it's all out there. When we're talking about the SEC rule, though, there's one audience that the SEC cares about. It's investors. They want investors to have full and fulsome information about what's going on, from the nature of the threat to the actual risks that are out there. And that's the way you need to view this rule. You don't look at it necessarily from, well, will this help the Defense Department or Homeland Security track down a threat actor? Is this going to be important because credit card information or, you know, my prescription chart from Harris Teeter has been stolen? No, this is about you and me as someone who has a 401k, hopefully, has invested in businesses, et cetera, and saying, boy, is that business in trouble because they can't produce Oreos, or they've had their crown jewels of intellectual property stolen. And does that impact how I have my portfolio and individual investment decisions? That is what is at the heart of all of this. And it's not just any one incident that the SEC is saying has to be disclosed. It's that even if there's a series of related unauthorized occurrences, if they're material in aggregate, they are going to have to be disclosed as well. So even if you have a bunch of small incidents that have occurred, but that they don't seem material individually, as long as the aggregate impact and their related events is material, then there's going to be a requirement of this 8K disclosure window. And that's an SEC filing, as David can talk about, this 8K. Important to note here, too, is that the SEC has made it clear that they're not going to tolerate businesses and business leaders dawdling when it comes to making the actual decision as to whether something is material. They're going to expect you to make it in a reasonably judicious time frame. And if you disclose at a later date and you said, well, it just took us several months to determine whether the event was material or not, that in and of itself could trigger an SEC investigation. So that's really important for you to realize. And this, where the SEC landed with the final rule, is a little bit narrower than they initially proposed, where they even said a series of unrelated, unauthorized occurrences are going to potentially trigger the disclosure rule if they're material in the aggregate. Now we're looking at related events. That's a bit of a relief from businesses because you don't really have to be looking for all those needles in a haystack and see what they can actually put together at the end of the day. This is a series of events that clearly are related that become material. Now, one other important thing that I want to note that I think is very important and sometimes gets missed, when we use the language of the cybersecurity disclosure rule, we're all thinking about hackers, and that's going to be the majority of these events. Do note that the SEC disclosure rule actually also applies to accidental occurrences as well. And so it could be something as simple as you're implementing a patch and that causes some sort of problem that is going to lead to production delays or financial woes, et cetera. That too is disclosable or a required disclosure under this SEC rule. Obviously, though, we're focusing more on these cybersecurity issues because those are the ones that come to the forefront more regularly. But it is important to note the wide breadth of this rule and how it can impact both, accidental as well as deliberate events. In addition to the event disclosure, now in public filings, there's also going to have to be disclosure regarding risk management strategy. What processes, if any, are used to assess, identify, and manage material cyber risks, and use of third parties, like the brilliant Dragos, integration into overall risk management, the process to address third-party risks, and whether these risks have materially impacted strategy, operations, or financial conditions. David and I have started to look at some of these filings. And in fact, this week have been reviewing some draft filings from some of our clients on this. And to be candid with you, we're in the very early stages of what this language is going to look like. We expect feedback from the SEC, some gentle, some not so gentle, on whether these disclosures are adequate, whether they need to be revised, bulked up, et cetera. But do recall, table stakes at this point is that you're going to have to disclose what your risk management and strategy is to address cybersecurity and other material cyber risks. This is a requirement going forward. You're also going to have to disclose information about the board and management's oversight role. Talk about who on the board is and what the board is going to be doing with respect to cyber risk, which committees are responsible, and the processes to elevate cyber risk, and the management's role in assessing and managing risk, including who's responsible for that, again, what the process looks like, whether the management elevates the cyber risk to the board. And I mentioned earlier, are there processes in place about this? I would say to you, a gentle free legal advice, or maybe we'll just call it consultant advice in this particular case, so my general counsel doesn't yell at me. But if you don't have a process to assess risk, to respond to events, to elevate the risk to management, and then to the board, et cetera, the absence of that is going to be a problem for you. And so this is yet one more push from a government agency, in this case, from the Securities and Exchange Commission, that is saying it is time to formalize and time to be familiar with your processes to assess the threat, assess the risk, and respond to it. I would dare say a complete absence of that at this point is putting your company at a slight, we'll call it an elevated possibility of additional questions. We'll put it that in that very gentle way. But I would also say if a company came forward to us and said, "Oh yeah, we don't really have a process to manage cybersecurity risks and manage it," I think even before this, you'd get at least one raised eyebrow from me, and I can't raise it too far, unfortunately, to get a really cool look going. But it would certainly be a situation of, well, you might want to think about changing that. And of course, a critical question related to all this is exactly how does the SEC determine materiality? We get that all the time, and I'll actually turn it over to David here to get his thoughts on what materiality actually looks like.
Thanks, Brian. So we're going to have a whole section for you on what materiality looks like and the processes that Brian alluded to that companies should have in place in order to ensure compliance with the new rules. But I think Brian's discussion and analysis of the new rules really begs the question of what are the specific hooks that the SEC Enforcement Division has in its toolkit in order to pursue cybersecurity related violations at public companies. And I think with one important exception that we'll discuss, the cyber enforcement actions that the SEC has brought to date over the last 7-8 years, they focused on two categories of violations. The first involves false or misleading disclosures regarding cyber incidents and cyber risks. And the second involves inadequate disclosure controls and procedures. And what that refers to is a set of processes that public companies are required to have that ensure that when a company experiences an event or has information that might be disclosable, so potentially about a cyber incident or otherwise, the company has processes that are in place to ensure that information regarding that event or that risk flows up the corporate ladder, so that folks responsible for making disclosure decisions and materiality judgments have all the information necessary to do so. And we're going to talk about what goes into that. We're going to talk about materiality determinations in the cyber context and what the security folks can be doing to ensure that the people responsible for disclosure decisions have all the right information. One question that many people have asked since the SEC started focusing on public company security roughly a decade ago is, in the absence of a disclosure failure or in the absence of a disclosure control failure, can the SEC go after public companies for just having what the SEC considers to be, in the exercise of its hindsight judgment, to be inadequate security? I think the jury is very much still out on that one. And I actually mean that literally, because the SEC included this very theory in the SolarWinds enforcement action. And unless there's a settlement in that case, which seems unlikely, it's likely that a court will determine whether the SEC actually has that authority to assess the adequacy of your security. So we're going to talk about all that in a little more detail, but for now, I'm going to turn it over to Betsy to talk about how these requirements actually fit into the OT incident response process.
Thank you, David. I'm Betsy Guarneri, General Counsel of Dragos, and want to thank both David and Brian, colleagues and partners over at Pillsbury, for giving me this opportunity to speak on a topic that's top of mind for everyone. And it turns out that the Pillsbury folks are experts on. When I started researching this webinar, I ran into their previous webinars on the subject, and am thrilled to be able to kind of, gain some insight from their expertise and put a, kind of the security-minded focus on where we think this all fits together. So when we're talking about, kind of where cybersecurity disclosures fit into the OT incident response process, taking a step back, wherever the SEC winds up landing on determining whether or not you have adequate security in place, we're the folks that are going to help you make that never be a question. We're going to come in and try and ensure that your security is not going to be questioned. And so going through that, kind of just wanted to put up what a typical IT, incident response process looks like in OT. Mark has already walked us through the OT cybersecurity landscape, and made it clear that there is the potential for real harm to people in the environment that can result from impacts to disrupting OT systems. Just yesterday, the FBI director got in front of the House to testify about that very scenario as China targeting U.S. critical infrastructure. When we're talking about the general scope of the new disclosure requirements, there's going to be some different considerations when you're thinking about, am I disclosing a material IT security event, or am I disclosing something that's in the OT space? And that's when you're going to need to lean on your OT experts, because they're going to be providing the facts that are going to help determine that. So a couple of takeaways when you're looking at this. Preparation is key. You want to prepare for incident response well before there's ever an incident. And you're going to want to make sure that at every stage of the process, it's documented and you've practiced it, and there are clearly defined lines of communication between the people that are investigating and handling the incident and the people in your organization that you're going to task with determining materiality. Each stage of the incident is going to uncover new facts, and they could shape the materiality determination. It could be at the identification stage. It's clear this is a material impact. This is going to be something we're going to need to disclose, and the clock starts at that point. Or it could be that you're going to start having to spend a lot of time figuring out who are the stakeholders, who you're bringing in, And what kind of things are we going to need to just even get a sense of before you can even begin to understand what you're dealing with. When you're looking at who's going to be making the materiality determination, you can guarantee it's going to be multiple stakeholders. So you need to plan ahead for that. Some companies are going to want to have their executives making the determination. Others are going to want to involve the board. There's clearly a trend moving towards the board involvement on these matters. I think that we'll probably will get some guidance from that as the SEC kind of weighs in on these things. It's going to be possibly in your interest to set up a committee. If you already have a committee that deals with public disclosures, perhaps you're putting one together that's solely focused on materiality. At the identification stage, as I mentioned, you may not have enough information at that point for materiality. So this is kind of baked into the structure. So you get an initial reasonable time to assess, factored in the disclosure requirements. But you also kind of have to understand that there's going to be some, backward-looking judgments about what you decided at that point. Because as things come out and as they evolve, you're going to be putting disclosures out there if you do determine it's material. And that's, obviously going to have some time constraints involved. When the event eventually will hopefully move towards the containment or the eradication phase, that's going to have some other impacts that you're going to need to think about. Are we going to need to bring systems offline? What's that going to mean for our business? And how are you going to report that out to the public who's looking at you from, kind of a different lens as you're trying to recover from this? You're dealing with the idea that you've got investors that they're very interested in how the company runs, but then you also have to deal with all of the OT specific impacts. Is there a risk to safety? Is there other things to be considered? And you're kind of juggling all of those at the same time. So it will be really important to make sure that you've kind of run through this again and again. I'm going to cover a case study later in the presentation to walk through how these events might evolve. But in the meantime, I'm going to turn it back over to Brian and David, who are going to talk about more about best practices for disclosure requirements.
Thanks, Betsy. So having laid out the threat landscape and discussed the specific requirements of the new rule and the excellent framework that Betsy provided us in terms of how to respond and think about these incidents, we want to now give you a sense as to how the SEC is expecting you and your companies to actually comply with the new rule and share our thoughts with you on best practices for both OT and IT environments. In other words, I think what we want to do is talk with you about what the CISO and security community can do to stay out of the SEC's crosshairs. And I see that we've been getting a lot of questions in the chat about like how exactly is the SEC going to evaluate materiality? How should you be thinking about materiality in this context? So I think we're going to try to address all that in this section. So as Brian mentioned, one of the hardest decisions that folks need to make when applying the new rules is determining whether you've experienced a material cybersecurity incident. And I'll just start by going over the general definition of materiality, which is probably pretty unhelpful. And then I'll spend a few minutes drilling down on how we can actually apply that definition to cyber incidents, which will hopefully be a little more helpful. The main definition comes from an old Supreme Court case, and it essentially provides that information is material if it's important or it significantly alters the total mix of information. The definition seems straightforward, but there's one common misconception here, which is that some people think that the information has to be so important such that a shareholder is going to be inclined to buy or sell if the shareholder knew that information. But it actually doesn't have to rise to that level. It only has to be significant enough to just impact an investor's thinking about a potential investment decision. So if you experience a cyber incident, you can't avoid disclosing it under the rule because you say to yourself, well, it's not quite bad enough to make investors want to dump all the stock in the company. One other important point here is that the SEC has made clear, both in general and in the context of cyber-related disclosures, that to the extent you have any doubts, they have to be resolved in favor of actually making the disclosure. And also, just from the CISO and security team perspective, the goal here is to help legal, compliance, and other folks responsible for disclosure, whether it's the board, as Betsy mentioned, or otherwise, just how bad this incident was, or just how serious the cyber risk that the company is facing, to aid the company in its disclosure decisions. So now what we want to do is take that definition of materiality and work with that to start developing a framework for how we're going to apply it in the cyber context. And when Brian and I advise clients on how to do that, the first thing that we say is that you need to be thinking, broadly speaking, in terms of two buckets of information. The first is what we call incident-specific factors, which includes every aspect of a breach, including the nature of the threat actor, whether any data was compromised. In the case of an OT-related incident, what are the operational ramifications of a breach, or potential ramifications, and of course, other sources of harm. The second bucket includes what we refer to as company-specific factors. So what are the aspects of your company or your industry or your sector that may render a specific incident that you experienced or may experience either more or less significant? So for energy companies, just as an example, does a particular type of incident have broader ramifications for the national energy grid and things of that nature? When doing their own analyses of cyber incidents and evaluating how companies respond, the SEC staff is going to be evaluating this through the same lens. And I can tell you that based on current cyber matters that the SEC is looking into, under this incident-specific category, the SEC has been very focused on threat actors that are both persistent and sophisticated. And if your company is dealing with that type of threat actor, you need to really give some thought as to whether you potentially have a disclosure obligation, even if the tangible harm is quite minimal. So at a very minimum, that's the sort of thing that you want to make sure that you are escalating as part of a disclosure decision. So having a persistent and sophisticated threat actor is definitely one factor that the SEC considers to be a red flag of a potential material incident. And I want to be clear that there's no exhaustive list that can give you a complete checklist of what might be material. But these are the sorts of things that might be useful examples and hopefully provide some insight into what the SEC staff is thinking when they evaluate whether a security incident is material and may trigger a disclosure obligation. Some of these items might be obvious. If you experience an attack that involves a high volume of data or important data, that's obviously something you want to consider as part of your decision-making process. But one thing that I think this slide highlights is that when you think about materiality of cyber events, you need to be thinking both quantitatively and qualitatively. You can't just think in terms of numbers, like how many records were accessed or how long was a network down or cost in terms of dollars. Those things are important, but they're certainly not going to tell the entire story. And for that reason, in its release adopting the new rule, the SEC has stressed that in the context of cyber events, materiality just goes way beyond assessing financial condition or results of operations. And reputational harm is just an example of a qualitative factor, but it's something that you definitely need to consider, along with things like relationships with customers or vendors, and how an incident or a risk may impact your ability to be competitive. There's a couple other items that are worth pointing out here. One of which is there's no exception for incidents that occur on third-party systems, so long as they have an impact on you. What that means is if a threat actor breaches someone else's network and your security is perfect, that could be a disclosable event for your company, even though you did everything perfectly. And a question that sometimes comes up in that context, and it may have come up in our Q&A here already, is how you disclose cyber incidents that occur on third-party systems when you might not be aware that it happens necessarily, and even if you are, you don't necessarily have enough details to make a fulsome disclosure. The unsatisfying answer is you kind of have to do your best and ensure that you have some processes in place, whether through contracts or otherwise, or through a diligence process, to find out about these incidents. But the key is that it's not a standard of perfection, and you'll be judged by a reasonable standard. The last thing to consider here is that when making materiality decisions, you need to consider whether enforcement authorities might launch investigations in the wake of a breach, as well as the likelihood of litigation and associated costs. One question that we often receive in the wake of the SEC's rules, and also in the wake of the SEC's enforcement action against SolarWinds and its CISO, is what is the role of security experts in making these decisions? And I'll just say, just to give you the bottom line up front, the CISO and the security staff should not be responsible for making these determinations. I think the SEC would view that both as an inappropriate delegation of roles and also potentially a control failure. That's not to say that the security staff doesn't have a crucial role here. In fact, I think they have the most crucial role, which is to help the folks responsible for disclosures make sure that they understand all the relevant facts. How bad was the incident? Is the incident contained? What's going to be the scope of remediation? Those are all things that have to be part of an ongoing dialogue between the security staff and others, so that the folks who are responsible for making the disclosure decisions know how to come out. So the CISO and the security staff have to be actively involved, but never making a final decision, because that's just not going to be viewed as appropriate from the SEC's perspective. One question that we sometimes get is, or another question is what types of policies should companies have in place to ensure compliance with the new rule? I'm sure most companies, as Brian was mentioning, incident response policies and escalation policies and disclosure controls in place. But in the wake of the new rule, Brian and I think many others have been advising that companies consider adopting policies and procedures regarding materiality judgments for cyber events. These should be developed with the security team and the legal team. If you're going to have these policies, they should be tailored to your risk profile. And what this does is it gives you an opportunity to actually think about in advance what types of incidents are likely to be material for our company. And a very important thing to keep in mind here is that materiality or assessments are often subject to management judgment, which means that the SEC might very well at the end of the day think that you've made the wrong decision. But if you have robust policies, if you implement your policies, if you follow your policies to the T, even if the SEC disagrees with where you ultimately come out, it's going to be very difficult for them to bring in enforcement action. So that's something to definitely be mindful of. Mentioned earlier that public companies are required to maintain adequate disclosure controls and procedures. The only thing I want to emphasize here before moving on is that in the event of a breach, the SEC is going to be assessing how quickly and how effectively information moved from the security team up the corporate ladder to the C-suite. Every enforcement action, including SolarWinds, has involved a disclosure controls and procedures component. It's going to be especially important here in light of the timing of the new rule. The materiality determination must be made without unreasonable delay, and the SEC is going to be considering a lot of factors in making that determination, including how quickly decision makers were convened, whether the company complied with and had internal policies and procedures. So again, at the risk of being repetitive at this point, the SEC is going to look at those policies and procedures. So it's important to make sure now's the time before any breach or incident that you're making sure that you have adequate policies and procedures in place. The policies should cover both identifying and tracking cyber events, as well as elevating cyber events. And so now with that, I'm going to turn it back to Brian to talk about the national security and public safety exception, delay option that Brian mentioned earlier.
Yeah, thanks, David. And I just wanted to mention one thing, building on what you were chatting about earlier, with some of the earlier examples from the SEC, like Blackbaud and SolarWinds and others. I would note too that there was a matter in the past year or two where a large financial institution, Morgan Stanley, no offense to anybody from Morgan Stanley on the call, they're also a client of Pillsbury, so we're not speaking on their behalf. All those good things where there were allegations from the SEC that resulted in fines. And in that particular case, it was a rather sort of, I think, minor incident where the Morgan Stanley had been decommissioning some hard drives and some computer equipment, and allegedly some personal information remained on those hard drives. The key points here are that Morgan Stanley had a $35 million fine imposed on it by the SEC for this alleged privacy lapse. And critical to that and relevant to the disclosure rule were assertions from the SEC that Morgan Stanley failed to adopt written policies and procedures related to data decommissioning. It's the existing written policies and procedures for monitoring of vendors were not reasonably designed for security and confidentiality purposes, and the company failed to take reasonable measures to protect, in this case, personally identifiable information. That is relevant, again, not to pick on Morgan Stanley in any way, shape, or form, but it is relevant because it is a great, not direct precedent, but it is, I think, very influential in terms of what the SEC might say if it investigates a cyber incident in one of its registered companies. I mentioned it earlier. I'm going to say it again. They say, do you have written policies? Think of that as you should have written policies. If you don't, call Betsy, call Mark, text them, Instagram message them, whatever the kids say, Snap, these, whatever, do it. You need to have those policies and procedures in place, including incident response procedures right away. You also need to make sure that those procedures and policies are reasonable for the threat you're protecting against. That is obviously a bit more in the eye of the beholder, if you will. It's a subjective call, but you still need to start looking at that and saying, is this reasonable for the threat we're facing? And in the case of Morgan Stanley, it was relating to data for companies that have operational technology. Is this to keep our operations up and running, the delivery of energy, the production of widgets, et cetera, that type of thing. All of that is going to be critical, and you're going to need to make sure that your policies and procedures map to your risk assessments, the threats you're facing, and making sure that they're designed to mitigate or eliminate as much as possible, really mitigate material events. I just wanted to throw that out there because I think it is a highly relevant example, and happy to discuss that a little bit more. But what we also get a lot of questions on are this exception that is allowed for delays to the 4-day business rule, 4 business day rule. Again, you have 4 days from a determination of materiality to file a public disclosure that you've suffered some sort of cyber incident. There are this exception here, and it's really a national security / public safety exception. I mentioned before, it can run up into 120 days and beyond, the first threshold as to whether this is going to be granted is through the Attorney General. The Justice Department has issued some pretty specific guidelines on what they think are what might allow for a delivery of this exception. It's going to have to be claims related to national security or public safety. And you can maybe get a 30-day delay. You can maybe get some additional delays on top of that. And then at the end of the day, it's the SEC to make the final decision as to whether a delay is occurring. But initially, you're going to go through the Justice Department, really the FBI. You can go through your other sector risk management agencies. So if you're a pipeline, you can talk to TSA. If you're a healthcare company, you can go talk to HHS and the Office of Civil Rights. You can, trains, go talk to TSA, other agencies like that. They're supposed to have created points of contact that would communicate to the FBI and the Justice Department. You're probably best off going to the Justice Department just because of the time pressure here. We're talking about 96 hours. I had to do the math. I had to take off my shoes. I'm a lawyer because I can't do math. So I got to 96 hours, 4 days, 24 hours times 4. Thank you very much. I'm sure my math teacher will be proud of that. But that's what you're dealing with at this point. And you're going to want to have to prepare for that. And frankly, you're going to want to be prepared beforehand to seek the exception. Now, is an exception realistic? The answer is not really. The Justice Department and the SEC, the White House, have made it very clear. Exceptions are rarely going to be granted. Okay, this is the unfortunate reality. They are probably going to say, you should be thankful we're even thinking about giving an exception. The initial draft of the rule didn't allow for it. It was only after extraordinary pressure from industry and even from Homeland Security itself that there was this exception put into place. And as I mentioned, the Justice Department has put out guidance on it. Those of you on this call, and there's probably a good number of you who are in critical infrastructure, you're in better shape than most other businesses. If you're making t-shirts for your favorite beach bar, probably not going to get this. But if you're in critical infrastructure, you stand a greater chance of getting a delay in the public disclosure. And that's because there are serious national security and public safety concerns as addressed and enumerated by the Justice Department and the SEC, some of which they say include if the disclosure would undermine remediation efforts for critical infrastructure, or the attack method is using a tactic or a technique for which there is no widely known fix. Or, and of course, how generous the government is thinking of itself. So if the attack hits sensitive government information and disclosing that would cause wider national security harm. But that's really it. I mean, there are potentially other exceptions that are out there. We're certainly open to more novel interpretations and pushing that with this Justice Department. Probably want to do that beforehand, not later. It could change with a change of administration, change in Congress, et cetera. That's speculative, but really the reality is that you need to be prepared for the fact that this 96-hour, 4 business day time window is the one you're working in. And again, if we're talking about making sure you have policies and procedures in place, prepare now. Think about what you're going to need to do, even though obviously you don't understand what the specific event is, you don't have that kind of clairvoyant knowledge. You know what you might need to do in order to communicate to the Justice Department, the FBI, other agencies in order to potentially seek that. Start that process now. Free tip. You don't want to know my hourly rate. It's outrageous. I wouldn't pay it, but it is quite big, and oftentimes you got to have multiple people on the phone making those types of disclosures. You'd rather get that out of the way up front than have everybody scrambling. Water's always more expensive at the scene of the fire. And of course, if you're a company for which incidents are likely to have a national security implications, you want to document beforehand what those potential national security or public safety concerns are. Make sure you know internally who is responsible for seeking those delays, and reach out beforehand. Get to know the FBI folks, get to know the people in the TSA, get to know the people in the EPA, others who are going to be your advocates, hopefully, in pursuing this 4-day delay. Again, this is not something you want to exercise at the time of the event. And you can do a Google search and figure out who your local FBI field office is, what's their phone number. Good luck getting them to pick up the phone. For instance, there is going to be an email address in which you can send these requests. Who knows how quickly they're going to be answered or even considered. You want to be prepared beforehand. And so with that, that finishes up my part of the presentation, and then we can go hand it back over to Dragos for a discussion about collaboration across the enterprise.
And on that topic, we decided we were going to take a quick look at a case study. And I know we're really running out of time, and there's a lot of great questions that are coming across, so I don't want to spend a lot of time on this. But we did think that unfortunately for Clorox, it winds up being the interesting case study that we had in mind. They had the unfortunate distinction of having an incident right before the new SEC rules were rolled out. So it not only garnered a lot of attention when folks started noticing that their products weren't on the shelves, but also for all of us who had been paying close attention to the new disclosure rules and how companies are going to be in handling the requirements. It is interesting to watch and just, dove into the Clorox disclosures and see the evolution of what they were disclosing as it went along. It's also interesting to note because it was an IT incident that had operational impacts. And so, kind of the key takeaways are, obviously, as I had kind of walked through the incident response process earlier, the information is going to evolve. What you know and when you know it will be, a discovery that you go on with a lot of different stakeholders, and coordinating that time frame and the people involved to get to disclosures that kind of go out into the public is going to be key. So when they initially disclosed something in August, it was essentially we saw some unauthorized activity on our IT systems, and we've got some disruption. By September, it was pretty clear that it was a material impact, and slower production rates, elevated level of consumer product availability issues, and then it played out by the time when they issued their Q1 financials. There was a quantifiable impact, about $356 million decline in sales, mostly attributable to the attack, and announcing further impacts into 24. So important to kind of see how your disclosures may evolve as this goes along, making sure that you've got all the stakeholders in place and that you've got the plan for these disclosures, because it's going to be, obviously a really public facing announcement of your incident and what you want to kind of make that a part of the public knowledge at that point. We do want to emphasize, because we're a cybersecurity company, that defense is doable. And so to that end, we always highlight 5 critical controls, which I'm going to ask Mark to tag back in on. But one of the controls is an ICS incident response plan, and that's going to be very different from an IT incident response plan. And that's just one of the things that, I would presume that Clorox is probably reevaluating at this point, just to see kind of how things had evolved in their own incident. But Mark, gonna have you take over on the critical controls.
Yeah, thank you, Betsy. So with the emphasis on cybersecurity in general, changes in regulation, more communication coming from the government, it seems daunting, especially when a lot of the networks are not fully understood even by the people that operate them. So there are multiple different approaches. The insurance industry has 12 steps. Dragos worked with SANS, and we put out 5 critical controls. Whichever model you want to frame as a journey, I would say plan an iterative step approach. And the first one that we identify, and really ICS or OT, but it applies to IT as well, and that's create an incident response plan. You heard a lot of people in the conversation today talk about as I believe David mentioned, there is no, hard line in the sand on what should be included and what isn't. So as long as you can demonstrate a channel of communication and show that decisions that were made were informed and those channels of communication are documented, you're in a much better spot. And so the first step, if you can do one thing this year to improve your cybersecurity, it's to document that incident response plan and test it. A lot of times we hear, create an IRP, incident response plan, make sure you test it. what I'd like to highlight on that is that test needs to include all the stakeholders. It needs to include legal representation if you have it, insurance if you have it. It should have those escalation points up so you've got those decision makers identified and the frequency at which they will be involved. Bring them into your tests, establish that rapport with your external stakeholders before an incident. So just highlighting again, if you have one goal this year, it's document, have that incident response plan, have your disaster recovery or your business continuity plans tie into that. Not every incident may be adversarial driven, but make sure that you've tested those and you can demonstrate that those decisions made were informed. So want to make sure we have a little bit of time for Q&A. So thank you very much again, Pillsbury, and all participants for joining today. But Jennifer, I'll hand it over for questions.
Thank you so much. Well, we are running short on time, but I'm going to try to get as many of these in as we can, and we can run a couple minutes over if folks want to stick around. So first set of questions we had was around eligibility. People asked about subsidiaries of publicly traded companies, private companies, public utilities. Can you speak to, maybe Brian, could you speak to eligibility of these requirements?
Yeah, I'd actually turn that over to David as the SEC expert. A company is going to largely know, I would say, though, if they are regulated by the SEC. I mean, a strong hint is going to be if you have a compliance officer in the company who's responsible for making a filing to the SEC. But, David, I think David's going to be in a better position to talk about some of the subsidiaries and other issues like that.
Yeah, I think the subsidiary question is a good one. The answer is that materiality is going to be assessed from the perspective of the public company, of the actual issuer, the parent company. But that being said, the question of where the incident occurs is definitely relevant, because even if it's a subsidiary or an affiliate, if it's a particularly important subsidiary or affiliate, that's going to play into the materiality determination, because the SEC is going to take the position that a cyber incident experienced by an important affiliate or division or subsidiary of a company is going to weigh in favor of a finding that the company itself experienced a material incident.
Okay, great. And then what about private companies? This doesn't call out private companies for the SEC, but what do you think are some implications of this for private companies? And then can you just remind everyone about public utilities and their responsibilities here?
So maybe, Brian, I'll start with the private company part and then turn it over to you for the utility component. On the private company part, to the extent that the company is issuing securities and has investors, you still have to be honest and truthful and complete when you're making disclosures to your investors. So the specifics of the rule might not apply, but if you're making disclosures about the state of your security program, they do have to be accurate and complete. And I think the other point worth noting is that if you're a private company and you're contracting with public companies, the public company might seek to some extent, import some of their compliance responsibilities to you, because I had mentioned earlier that from the public company perspective, the SEC doesn't care where a breach or incident occurs or where a risk arises. So if you have a relationship with the public company that could be a source of risk, you should expect that that public company is going to be relying on you to provide them with information so that they can satisfy their disclosure requirements.
Yeah, I would just add from the utility perspective, I think, again, as David pointed out, if they're issuing securities that would put them under the jurisdiction of the SEC, then this is likely to apply to them. The SEC uses the term registrants when talking about who this rule applies to. So you've got to look at that with the broadest lens possible. Now, of course, if you're wholly publicly owned, I mean, you're a public entity, municipally owned, et cetera, that type of thing. You're probably going to have different disclosure requirements for, Sunshine Act, that type of thing. But again, you would look at whether these public utilities, these public entities, et cetera, if they're going to have some sort of obligations imposed upon them by the SEC because of the securities they could be issuing, then that's going to be critical for making that determination as to whether the disclosure rule applies to them.
Thank you. I'm going to go back to David for a couple of questions on the SEC's role and what we anticipate seeing from them. Someone asked about, a couple of people actually asked about ransomware and some of these ransomware actors coming and reporting companies to the SEC, like kind of getting a jump on those disclosures in order to strengthen their plea for ransom for the money. So what do you think, David? What do you think about how the SEC is going to kind of handle that and look at that? Go ahead and answer that one, and then I've got two more follow-ups on SEC.
Yeah, I mean, I think that the SEC is in a bit of a tough spot on that one because based on the actual plain language of the rule, if a company experiences a cyber event, no matter where it occurs and who the threat actor is, or what the threat actor's motivations are, that's a disclosable event if it's material. Now, I will say that to the extent that a company finds themselves in that position where they're being subject to ransomware attacks with the threat of the threat actor actually going to the SEC, that actually provides an opportunity if you have the controls and you have the security in place to proactively detect that threat actor, or in the case of ransomware, if they come to you first, that actually presents an opportunity for you to go to the SEC and report that and potentially position the company to be in a position where they're going to the SEC first to preempt the threat actor who's attempting to perpetrate a ransomware attack, and that could have all sorts of benefits for the company.
Okay, thank you. Next question is about how the SEC determines whether a company had enough cyber protection in place prior to an attack. So, did they try hard enough to protect themselves against a potential incident? Is that the question that the SEC is trying to answer? And do you have any insight into how they'll answer that?
I think it's a great question. It's definitely a question that the SEC is trying to answer. I think I mentioned earlier that there's a debate as to whether the SEC actually has that authority for public companies that are not otherwise regulated. They've definitely taken the position in the SolarWinds enforcement action that absolutely the answer is yes, they have the authority to police public company cybersecurity. And so they're definitely going to be looking at not only the security policies on paper, but the adequacy of how they're implemented. And I think I actually want to turn that over to Brian to talk a little bit more about that last part.
Yeah, the adequacy issue is going to be a challenging one for a lot of companies. I think, again, I would turn back to the same comment, which is that, first of all, have the policies and procedures in place. If you don't have them at this point, then there's almost certainly going to be some issues raised. But it is going to be a discussion, and I think it might be somewhat of a lengthy discussion, particularly in the beginning, because to be candid, the SEC isn't necessarily the most technologically sophisticated agency within the federal government. There's certainly a shortage of experts, particularly OT security experts within the U.S. government. So they may not understand that certain threats or certain events are likely to occur just because it's difficult, if not impossible, to secure certain assets, or if you're dealing with a particular adversary like a nation state, if they want to get through, they're going to get through. And so that's going to be a conversation. It is that is why it's going to be critical in my mind, not only to have the policies and procedures, but to have contemporaneous documentation as to why certain decisions were made and why they were deemed reasonable and appropriate at the time those security decisions were made or adjusted on the fly. And I think, again, from the Dragos perspective, I think that's where they can be very helpful as well, is to make sure that your policies and procedures match up to the threats that you're facing out there. You want to look at the probable, not necessarily just the possible, because if you're investing in preventing the possible, nobody has enough money to protect against that.
Yeah, that's a great point, Brian. And as we close out, I want to throw one quick question to Mark Stacy to talk a little bit about, in the OT environment, severity is very difficult to assess right away, especially by management and boards and things like that. Operational impact can't even really be fully comprehended by many engineers individually. And shouldn't, companies do like a level of protection analysis, an architecture review? Like, talk to us about kind of what you should know about how your systems are set up before you ever even get into an incident.
Yeah, it's a great question. And we see that with insurance as well, where preparation or left of boom, as we sometimes say, can be quantified and calculated. Right of boom in these environments is essentially unknown because the impact, it's very difficult to qualify that impact. As well as any return to service, we may enter debates on betterment and other influencers there as well. And so identifying that impact is very difficult. I think going back to there are multiple cliches. Sun Tzu, know thyself, or understand what you're trying to protect before you apply protections. That's really where to start, is understand what is on your network, understand what you have. And going back to really creating some documentation to show that, yes, maybe the decision made the SEC disagrees with, but as long as you can demonstrate it was informed, that you did due diligence to make sure it was a data-driven decision, that is useful. That will be difficult to do if you don't understand your network. And this is one where absolutely call Dragos. We're happy to help, but you can do some of these iterative steps yourself. Go down and meet with the engineers, talk with the operation folks, talk with the IT staff, and make sure they have a voice and they're heard, you understand their concerns, and then document that you acknowledge their input. It will better your position, better your communication strategy. I wish I had a better answer on understanding the network, but implementations are different, vendors are different. It's really just going through that effort to understand what you have prior to deploying any type of protection.
Thanks, Mark. Okay, so I think that's the last question we'll have time to answer today, but we do see the remaining questions in the Q&A, and we will definitely reach out via email. So panelists, thank you so much for sharing your expertise, and thanks to everyone who joined us today. Great discussion. Look on the Dragos blog for a follow-up blog. We plan to do that in about a week, and we'll have the recording and slides out to all of the registrants after this event. So thanks so much, and we'll see you next time.